The Honest Money podcast is brought to you by Prescient Investment Management. We consider everything to give you the advantage. It's the future of investing. Prescient Investment Management is an authorized FSP.
Welcome to Honest Money. I'm Warren Ingram.
I'm Pieter Villiers from Money Marks.
So, Pieter, we're doing something which is new for me, but you're an old hand at this. We're going to do almost a little mini series to use TV language, and it's around the broader concept of estate planning.
Yeah.
And then today we're going to talk about wills, and it is an important topic. So I think we must cover this, because I know if you're listening to this and you go, oh, come on, I'm 23 years old, I'm never going to die. Well, I'm sorry, I've got bad news for you. Let's hope that that happens a long time away. But a will is an incredibly important part of financial planning, of investment planning. And so I think pretty much everyone needs a will. I don't care if you're worth 100 million or you're worth 2 cents, or if you've got negative assets. You need a will, and we're going to get into that topic, and then in future episodes we'll get a bit more into about what happens actually when you die, and then how you can do some planning around that.
Yes, yeah. There's only 2 certainties in life. I think was it Benjamin Franklin that said it: death and taxes. We've talked a lot about taxes, and that's very important. But we also talk about death. What happens? And I know it's not the most exciting thing to think about, but that's probably the only guarantee we can ever give you is you will die. It's the given. It's just going to happen at some point.
And the sun will rise. I like that. Yes. I mean, the sun will rise again. So the three, death, taxes, and the sun will rise. Those are guarantees.
Yeah. So planning for death is not, it's not something you do for yourself. It's something you do for your family. It's being responsible and taking ownership of making sure that they will be okay. And again, it doesn't matter how old you are. Okay, at least if you're over 16 in this case. But it doesn't matter how much you have to your name. You have to have a written, hand-signed will in place that records your wishes. So we're going to talk about how to actually do this and what you need to look out for. But I think it's always good to explain what happens if you don't have a will. So let's play out that scenario. If you don't have a written record of your wishes upon death, what's then going to happen is your estate. So estate means everything you own, everything that has your name on it gets frozen. So if you have bank accounts, you have investments, you have property, all of that gets frozen, meaning you can't now cash out the money in the bank or the investments. It's there. Some executor, which is the guy that administers the estate, that takes everything into account, someone needs to be appointed to do that. And if you haven't done that yourself, if you haven't appointed someone, it goes to the master of the high court, which is some guy high up. And then what happens is your assets, what you own, is administered according to what's called the Interstate Succession Act. There's a formula that happens. Usually what that means is if you have a spouse and children, it will go to them in equal shares. If you don't have a spouse, it goes to the children. If you don't have children, it goes to your parents. If you don't have parents, it goes to your siblings. And if you don't have any siblings, or there's no one like traced close to you in blood relations, it goes to the guardians fund of the government and then just lies there. So then everything you've built up over your life could end up somewhere else. That's not intended where it has to be. So if that formula gets followed, it may happen that your assets eventually get distributed to beneficiaries that you would not have intended it to do. So it could go to ones that you didn't want to receive money, and equally, it didn't go to those that you wanted to. So that's very important. But I think the other components of this process, it just takes so long. If you have a well-structured estate plan, you have a financial advisor that helps you to structure everything. So maybe something you can also comment on in your experience, but usually it should take like nine months to maximum 1 or 2 years if it's well structured. But if you have no planning done or anything, that thing could lay in the air for years. And if your family is dependent on you, that's going to put them in very tough times, financial hardship potentially.
Yeah, I mean, I think nowadays people that that die with assets and have just slightly more than just a car and maybe a mortgage. It's taking about 2 years to wind up an estate now, because this master's office that you spoke about is a government department. Unfortunately, it's not doing well, like a lot of government departments, and the process is incredibly paper-based and incredibly manual. The people working there are unfortunately operating in terrible conditions. I know that when it rains in Joburg, the master's office gets into trouble. So it's a difficult situation. And now what you've done, if you've died without a will, is you have now handed over everything that you've got in your life to a government department that's not operating well. And so you've left, instead of leaving your family with a legacy, what you've left them with is enormous heartache and a real headache. And so, I mean, the process to wind up, a person's estate that doesn't have a will could take many more years if they've got some kind of complexity in there. And just very simple things, in your will, you want to tell people, hey, I want to be buried, or I want to be cremated, or whatever it is. Like, I mean, I know for me that, if I'm not too worried about my assets, I also know like how I want to go, and I think that those kinds of things you should be putting in there. And if you've got kids, and let's say, you and your partner die, and you haven't got a will, I mean, that's just, I mean, it's not a crime in South Africa, but I feel like it should be. I mean, parents of young children that don't have a will, I mean, it's just reckless, because you're not, there is no document now to say, this is who should look after our kids. This is how the money should be allocated. And, if you think, okay, I'm 35 years old and my wife's 35 years old and we die, our parents will look after that. Well, that's not a gift. What you've done now is you've got a 2-generation gap. And that's a nightmare. Like, I just think, will is such an important thing, and the mess you leave behind is so real. So yes, I mean, a good, strong, well-written will is important. If you're sitting, listening to this or watching us, and you go, well, actually, you know what, I'm single. I've just started work. I've got a rental agreement for a property. I've got a car that's actually, I owe money on, and my bank account is zero. Okay, so still no one knows what to do, whether you should be buried or cremated, number one. And number two, there is paperwork that's left behind that someone has to do, that you've just left mess behind. If you're adulting, then be an adult. Get a will.
Yes. Yeah, absolutely. And I want to touch on the kids situation as well, because I think it's so important. As a parent, you need to have a will. It's not a negotiable. It's not, I'll get to it when I have time. It's like, if you're listening to this and you don't have a will, or you're not sure if you have a will, that's as good as not having one. Go and get one. Like, this is probably only strong statement I'll ever make in this space is it's your responsibility. As a parent, you have to have one. Because again, if there's no written will for your kids, what's going to happen is you and your spouse dies together, all that money is going to the guardians fund, and they're going to decide how that gets distributed to your kids, how much they get for school fees, for maintenance, and all of that. And every time they need money, they're going to have to apply to the master's office, and that's going to take forever. So you're just setting them up for incredible hardships. So now that we've got the scare tactic out of the way.
That was the big lesson. Yeah.
It's like a paksela. There we go. All right, so how do we do this? How do we set this up? Is this complex? It's actually very simple. And in terms of who you use to set up your will, most big companies can help you with that. What you need is, first of all, record of your wishes. So it can sometimes be very simple, a simplified one-pager. But if you have more complex needs around, maybe you have kids, you have to have a couple of considerations that you need to think about. So we're going to use a bit of, I guess, technical jargon here, but I will try and keep it as simple as possible. Firstly, you need to appoint an executor, which is the company that will help administer everything. Dying is quite a complicated thing, because there's a lot of aspects involved. You've got assets that you've built up. So when you die, you need to pay taxes. You need to pay off all your debt. You need to, if you have property that have to be transferred to someone else's name, so there's costs involved with that. There's the way that whoever, if you have insurance policies, they need to pay out somewhere, and someone needs to ensure that that happens. So an executor is someone that facilitates this whole process and that does the heavy lifting for you. And usually it's a company, and it's a lawyer or accountant or a team of experts that will help with that. You can either nominate a company to do that, or you can sometimes nominate a family friend, and when you pass away, they can then find someone that can help with that. What I found, like, a lot of people are concerned about that aspect of, but the executor is going to cost me bunch of money. Yes, it is, because they have to do a lot of work. they can charge up to 3.5% without VAT and 4.025% with VAT of your estate value. But that is always negotiable. If you have a lot of assets, you can negotiate that down. But you need to have someone that is equipped to be able to do that type of work, because it is quite a dynamic range of things that needs to happen. So that's the one thing. If you have kids, you need to appoint a guardian who's going to look after the kids. And appoint doesn't mean write down their name and don't tell them. You have to have that conversation with them. If you're going to nominate your parents, so the kids as grandparents, ask them if they're going to be okay with that, if they're even up to the job. If it's a sibling of yours, they need to be, first of all, well equipped to look after your kids, because looking after kids are expensive. Will they be willing, first of all, and able? And then also, usually, if you have kids, it's good to set up a testamentary trust in case you and your spouse both passes away, which is just like a separate type of entity that has a specific trustees, people that controls the trust, that will then determine how the kids are taken care of. But then you appoint someone well, and then someone that's able and capable, because then your wishes are fulfilled in the way that you would want it, and it's not dependent on some governmental institution. So those are the kind of three important things that you need to include in the will. And then you need to word it correctly. So I guess, you can go and Google templates for wills and you can try and create something together, but I think it's worth the effort to work through a professional company, if it's an attorney or a lawyer, or there's a lot of, if you just Google, you'll find many different places, but it needs to be worded correctly. And the final point that I want to make is you can't digitally sign this thing. It's one of the few documents still out there that you have to print it out. You have to sign in wet ink, and you have to have witnesses, 2 witnesses. They have to be older than 14, and they should not inherit anything from you. They should not be linked to you in any way, shape, or form to receive any benefits. That's very important, because that will make the will invalid. And an invalid will is just as good as no will. It's going to go through that whole interstate process. So usually what I would say is, if you speak with someone that helps you set up the will, print it out, print 3 copies, sign all 3 in ink, keep one in your safe, send one to the company that they keep in their safe, and then another copy to friends or family or whoever you trust to keep in their safe. Because then you've got 3 copies, and then this thing is written and it's recorded. You tick the box, and then that is in place.
Yeah, I think the things to add there is just going back to the kids. I think you've got, parents need to have the conversation with everybody in the family about who's going to look after our children if we die. Because there are lots of court cases that happen, unfortunately, where the guardians are appointed, and then the grandparents get involved to say, no, but we are we family. We should be looking after our grandchildren. And so then you're left behind a mess. So you've got to have that conversation proactively. And talk to the people that are involved in all of this. As you say, don't if you've nominated your brother or your sister to be the guardians, the first time they find out shouldn't be on your death. They should know about it long before, preferably pretty much just after birth. And it doesn't mean that you can't change the guardians in your will at a later stage. So if circumstances change, relationships change, whatever the deal is, it doesn't mean that you've made a commitment to one particular guardian for life. So you can make a different decision later, but you should have that documented. It should be very clear to everybody in the family what you expect, and make sure that that's a live conversation. If you're a responsible parent, you want your parents to know that it's going to be your sibling that's going to be the guardians, for example, and then a discussion with everybody to say, of course, we want the grandparents to be involved in our children's lives. This is what we want for education. You might not have to write it down, but if you've got a view to say, look, we want our kids to go to XYZ as a school, or this kind of a school, we would like them to go to university if there's money. If they tell you at the age of 14 that they've decided they're going to become coders, unfortunately, they've still got to go to school. Whatever the deal is, have those conversations, be proactive. And maybe just on appointing an executor, I think it's a heck of a job. It's not a favor that you give someone to say, you're not giving them an honor for life. If you say, would you like to be my executor? What you've given them is a lot of work that they're going to have to do. So if you're going to appoint a family member, again, have a conversation with them And if you're on the receiving end of a question like that, if let's just say you're an accountant, doing the books for a business, that doesn't mean you're going to be a great executor. You might not even want to be that. But what you do know, what you need to know, is that you can appoint an agent. So if I'm an executor of a family member's estate, I'm not going to do it. Number one, I have no interest. I'm scared of all the legalities involved. It's an enormous amount of work. What I can do is I can go and appoint a law firm or an accounting firm or a professional executor as the agent. So yes, I'm still the executor, and I have the rights, but I can almost subcontract it out to a professional. So what you can do there is, if you're skeptical of professionals out there, and you trust your sibling, for example, to be your executor, by all means, but don't be surprised. And if you are that person on the other side of that, make use of agents. You can always negotiate executors' fees with those agents at that time. So, I think, frankly, 3.5% is cheap, actually, for the work that's involved in winding up an estate. For a very big estate, the fees do come down, and that's fine. You can negotiate those. And then my other comment is, it's probably the one of the few aspects in the money world where I think DIY is not ideal. Doing it yourself here, doing it yourself to draft a will, I'm not in favor of. Copying and pasting your mate's will. It might be great, when your mate had his will drafted 25 years ago, it might not be right. Things evolve in the world of estates. And I just think people who deal with estates a lot, they see the unintended consequences. You might have a particular view on something and you think it's a great thing to put in a will, and then a professional will say to you, if you do this, your kids are never going to be able to afford school. Something that you just didn't think of. So I would encourage you, we like to save fees, but I don't think this is saving money. I think this is, by not paying an executor or not paying someone to draw up a will. If you can afford it, pay someone that knows what they're doing. Maybe my last word on this part is, there are kind of two groups when it comes to wills. There's the accountants and there's the lawyers. The accountants generally have a focus on how can we make your estate as tax efficient as possible so you pay the least amount of tax. And that's not a bad thing, just understand that. But they don't necessarily think through all the consequences of who's looking after your kids and all. They just want to do things that are tax efficient. Well done to them. But the lawyers in this situation, because they tend to deal with a lot of the mess that comes out of doing wills as well, and the litigation around that, they might help you think about a will in a different way. So don't be afraid to get two quotes, for example, or have two conversations, one with a law firm, one with an accounting firm, and then make a decision, because I think this is worth doing a bit of homework on. Have a will conversation.
Absolutely, and it's you have to do it. It's not an option. And also, when drafting a will, something that I've seen recently being introduced is pets, adding pets to wills. If you've got Snippy at home and you're not there anymore, who's going to look after Snippy, and how do they look after them? So recording, you can actually do this. You can say, if I'm not here, this is what needs to happen to Snippy. Snippy needs this amount of money per month for food and for vet visits and for medication and all of those things. And I would like Snippy to be in this environment, because I think probably there's a lot of bad things that happens when you pass away, but a massive challenge is if someone has pets and no one knows what's going to happen to the pets. And oftentimes it leads to them going to a shelter or being euthanized, which is, a very unfortunate event, something that you would never intend for your pet to happen, but you're not there anymore to give an opinion. So it's foreseeing these horrible events, but then giving your wishes so that they are honored. And then you mentioned earlier, kind of like what happens to my body? Do I get cremated? Do I get buried? I know there's sometimes some strong religious beliefs around what happens to my body, and you need to record that somewhere, because that's your wishes. This is typically recorded in a living will, so it's kind of like attached to a last will that you sign together. And sometimes also another thing that could happen is, let's say you're in an accident and you're in a coma and you don't have any mental awareness anymore. You're kept in the hospital alive, essentially, by machines. Now someone needs to make a decision here. Are we keeping you on the machines, or are we pulling the plug? You're not there to give your opinion. So a last will is also saying, if there's no specific chance of me recovering, or it's not higher than 50% in the opinion of a professional, it's fine for me if my family pulls the plug. Again, not fun stuff to think about, but if you play out the scenario, you don't want to put this emotional strain on your family to make that decision. It's better to say, okay, this was Pieter's wishes. We've tried. He said this. Okay, let's do that. And that helps, I think, for them with closure as well in that process. Because never want to put that decision on someone. So it's foreseeing these events, recording it as if you were there, but you're not going to be. And then having a will in place is step one. And yes, it can always be changed. You can always amend a will. It doesn't mean like you're signing this legal document for life. You are, but you can change it. Essentially, you can, let's say you get remarried, or you get divorced, or you get kids, or you accumulate a large amount of assets. Maybe when you signed a will, it was when you're young, and now you own a lot more businesses and stuff. Then it's a good time to revise a will as well when there's a big major life transition. And that sometimes mean redrafting a new will, sometimes mean adding to the existing one. But whenever there's a big, massive, major life transition, go look at your will and make sure that the way that you phrase it is still applicable. And I think it's just something, good habit to revisit that a will document as if you revisit your insurance and your investments, at a specific period in time.
I mean, to me, I feel like every 3 years, if there have been no major life events, every 3 years, just check that the will's still current. Just reread it firstly for yourself. Remind yourself what's in your will, and then if you can get someone who's in the industry, in that industry, to have a look at it again, just to see if things have changed. And life events might be things that you don't even think about. If you're older and you've got adult children, they might have grandkids. And you might have a new grandchild that you have never catered for in a will. And so, life events could be much more than you think. And also be careful of ruling from the grave. So a lot of, there's some horrible cases, for example, where people, owned a farm in Zimbabwe, and that was one of their big assets. And then they would say in their will, this farm may never be sold. And then the president at the time authorizes land grabs, and people who would have sold the farm with foresight, who had the ability to do that legally, weren't allowed to. And so setting in stone, principles that you think are important, very specific things, might have unintended consequences, things that you can't imagine today that actually then unfold. So I think, reviewing your will every 3 or 4 years will help with something like that. But equally, then don't be so specific in a will that you prevent your beneficiaries from doing something which actually into the future might be a sensible, rational decision, because you prevented them by trying to accomplish something else. Saying our family home that we've got on the coast in whatever, should never be sold. Okay, well, oceans rise, and they could sell the house for some money before it gets flooded, and you've told them that they can't, and you can't undo that. If you've died and you've put this into the law, it's a heck of a thing now to kind of it's court cases and all that stuff. So I think stick to principles if you can, and also try and limit the quantum of assets that you specify in a will. It's one of those things where you say, okay, I'm leaving my beloved stamp collection to my auntie's uncle's nephew's son. If it's incredibly valuable, okay. But if it's not incredibly valuable, just tell them, tell the people that are involved in your life that that's what I'd like you to do. And the same with the stuff that's not incredibly valuable, because now what happens is it's all got to be itemized, and it's all got to be accounted for in the executorship process. And that's a mess. If it's no value or very low value stuff that just has sentimental value, tell people. I've even seen situations. I've gone into houses of people into their late 70s and early 80s. They've gone around and they've put little stickers underneath their items saying, this is Pieter and this is Warren and this is, and so they go. And gee, like that's not a bad way to go. But don't think that the will needs to be this 50-page document of every item that you've ever owned. That's also not true.
Yeah. And I think one last component that we can just touch on is a foreign will. Because if you have everything in South Africa, you've all your investments, all your property, everything in South Africa, great stuff. A local will is all you need. But when you start having money and assets overseas, the question often comes up, do I need a foreign will? So I'll give my view, and at least my understanding of it, is if you have property, physical buildings, so residential, commercial properties in another country, especially Europe, then you need a foreign will that speaks to that country's rules of probate, the way that asset gets distributed. Because you may have a South African will, but South African's law doesn't extend to the entire world. That country's law is firstly applied to that asset. So if it's a physical asset like a property, then yes, usually you need a foreign will. If it's an investment, a unit trust, a ETF on an international platform where it's maybe housed in Ireland, for example, but it's through a South African company, then generally you don't need a foreign will. You might just need a worldwide will. So it's still a local will. It just speaks to your worldwide assets to say that, okay, so all my assets, including worldwide, in terms of like these types of investments, get distributed according to these wishes. And that's usually, again, when you go take money overseas in international investments, it's good to work through a company that speaks to our South African laws and taxation, because then you simplify your life, and that's usually all you need. But in terms of foreign will, the way that I understand it is property overseas. That's usually when you need it.
Yeah, I think there's some countries, you mentioned Ireland is one, Switzerland is another, and then the Channel Islands, Guernsey, Jersey, Isle of Man. They will recognize the South African will. Actually, what they recognize is the South African letters of executorship.
Yeah.
So when your executor of your estate sends through documentation with their appointment as the executor, your death certificate, and the like, then they will act on the instructions from the executor as if it was you, and that's very important. But for example, if, as you say, it's mainland Europe or potentially even the UK, it could be a little bit complex, the US and the like, then you really should investigate whether you need a will in those jurisdictions. And I agree with you on property. I would say it probably also extends to things like unlisted investments, so businesses, et cetera, et cetera. If you've got any kind of an asset that's not on a stock exchange or an exchange traded fund or a unit trust, make sure you do the homework before you invest and make sure that you've got that correct. And we'll get into future episodes around death duties in those countries, in South Africa, etc. So we will cover that. We're not leaving it as a gap. We're just leaving a little teaser now to say that those things are coming. But certainly, if in doubt, check about a foreign will, because it's not true that you always need a foreign will, but it's also not true that your South African will applies everywhere.
Yeah, exactly. So if you don't have a will, go draw one up. If you're not sure, go find it. If you can't find it, go draw one up. And if you have one, it's maybe a good time to just read through it and make sure it's still recording your wishes as if it is written today. So thank you so much for watching. In our next episode, we are going to discuss, and this is a title that I thought would be interesting, how to die in the most cost and tax efficient way possible. Because we've now covered the formalities around setting up a will, but now actually what happens when you die and what is the costs involved, and then how can we make that as cost effective as possible. So yeah, thank you so much for tuning in, and we'll see you in the next one.
Thank you so much for watching, and please don't forget to subscribe.
Bye-bye.
The Honest Money podcast is brought to you by Prescient Investment Management. We consider everything to give you the advantage. It's the future of investing. Prescient Investment Management is an authorized FSP.